The DOJ wants to use a rule to go back and take Donald Trump's statements from not January 6th, but way before that, and use them against him. They're saying that those statements are relevant towards cobbling together the government's theory of a conspiracy, that he had been plotting and planning this insurrection for a long period of time and has made other similar baseless statements in the past, and now they can go back and dig those up. The rule is called 404B. We're going to take a look at what that rule means, but in context, it is being used by the government, Jack Smith, and in this case, Molly Gaston, you may know her as Highlighter Girl, the same one who says Trump doesn't really need to read any discovery because we already highlighted it for him, essentially. And she is drafting this saying, all right, Your Honor, we know trial's coming up in March, so we're just notifying you this is our intention. We're going to go back through all the history books, take every Trump statement that he ever said about any election anywhere, and use that, show that to the jurors to say Trump is a bad man. Now, that's called character evidence, right? You can't go through and say to somebody, well, this person probably committed this crime because 20 years ago he forgot to tip on his bill, right? Something like that. And say, well, he doesn't tip somebody, so therefore he's a thief. Wait a minute. You can't go back and say that somebody's character means that they acted in conformity with that character and therefore they are guilty of a crime. That's the general rule. But there are exceptions to that rule if you want to use that evidence for certain things. In this case, 404 tells us how it works. Now we're going to see what is happening with this little maneuver by the government. Then we're going to see what's happening with jury selection forms that are already being sent out across DC because trial is on track. Christie is predicting it's going to happen before the election, that Trump will be convicted, and Congress is seemingly taking some action here. They're sending a letter over to Jack Smith from Representative Luna and others. So we'll go into all of it, but first let's see what Rule 404 says quickly. I know this stuff can be a little bit tedious to get through, but we'll go through it quickly here. You see, it's 404B, and it tells us it's about character evidence, other crimes, and wrongs or acts. It says really the character evidence in general, evidence that is what it sounds like, it's about a person's character, is prohibited. You can't use that. Evidence of a person's character or a character trait is not admissible to prove that on that particular occasion they acted in accordance with that character or trait. So somebody maybe committed a robbery in the past, and so therefore they committed a robbery now, right? The past character, the past trait is not evidence of that. You can't say, well, it's more likely than not. You got to judge this case independently. Now, there are some exceptions if you're the defendant, right? If you're on the other end, or if you're a victim. Now, it tells us that for other crimes or wrongs or acts, what can you use this other evidence for? Stuff that is not really related to this case. Because when it comes to Trump, we're asking ourselves, what the heck does him saying something in 2016 have to do with January 6th? Or what does him complaining about an election in 2012 have anything to do with January 6th? We'll see. So prohibited uses, it says evidence of any other crime or wrong, right? Trump didn't commit prior crimes, but it's not admissible to prove a person's character. But you can, evidence may be admissible for another purpose. You can't show that because the person committed a crime like that or did something that was bad, that they acted in conformity with that. But you could say, but maybe it shows something else. Maybe it shows motive. You can use it for motive. You can use it for opportunity. You can use it for intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And this is one of those things they make you memorize in law school. And there's a mnemonic for it, and you write it down in law school and do your analysis on it. Oh, okay, it's 404 question. It's character evidence question. So you go through it, right? In a criminal case, you got to provide notice. So this is what the government is doing right now. They're saying, hey, guess what? We're using this. We know ordinarily we can't use it. We're going to try to squeeze this evidence in for this purpose, and that way we can get it all in. So that's why you're saying, Rob, it's not even relevant. It's from years ago. But watch, this is what they're going to do. Now they're going to articulate, they're going to do so in writing, and guess what? Guess what Judge Chutkan's going to do? Grant it. Okay, so we're going to go through it and see what is inside. So this is the filing here from the government. It's a 9-pager. You can see when we get into it, we scroll all the way down. Guess who's writing it? It's Molly, all right? Molly Gaston. She's the highlighter girl who said that Trump's defense doesn't really need to read anything because they've already been highlighted. She said, we already kind of outlined what our strategy of our case is, and so they don't need to really do their own reading or their due diligence, which is amazing. Thank you for prosecuting us and doing the defense as well. We didn't realize we lived in a tyrannical one-sided system, but all right. So here's what they're saying. This is the government's notice. They got to tell the court that they're going to go down this road, and of course, that's what they're doing, and it's under 404B, which is that character evidence rule. So here's what Molly says. All right, Chutkan, Your Honor, out of DC, the government will provide to Trump and the court extensive advance notice of the intrinsic evidence that it plans to introduce at trial, saying, we're coming in, Judge. It's December, and we're already waving our flag. This is where we're going, including through its exhibits and witness list, motions in limine, and a detailed trial brief setting forth the government's planned trial presentation. I told Molly loves the highlighters. Says, in an abundance of caution, the government below notices evidence that, although intrinsic extrinsic to the charged crimes pre or post dates the charged criminal conspiracies, okay? In other words, it's outside the hula hoop. It's outside the scope. There's a bunch of stuff that's relevant to the January 6th case. There's a bunch of stuff that Trump said that is not relevant, but they're trying to make it relevant to bring it inside the hula hoop. If the court were to find that any part of the evidence that we say is extrinsic, not really related to the case, the evidence is also admissible under Rule 404B, right? It doesn't go to the main question of the case. It's not going to Trump's innocence or guilt in this particular matter. So it's normally not allowed, but we could get it in under one of the exceptions. And because the government will offer it not to show that he has a propensity to commit a crime, right? He's not acting in conformity with, but we're going to show that it establishes Trump's motive, his intent, his preparation, right? He's been plotting this thing for years, decades. His knowledge and the absence of a mistake or common plan. Says, as set forth in the indictment, Molly continues to write that there is historical evidence of Trump's consistent plan of baselessly claiming election fraud, right? So it's not only in 2020, like this has been going on for a long time. Now, as set forth in the indictment, Molly writes, Trump's criminal conspiracies on January 6th relied knowingly on false claims of election fraud. And I think they're going to have a tough time proving that now that we know what we know. Now, at trial, the government, says Molly, will introduce a number of public statements, things that Trump has said, again, his free speech is being criminalized here, by Trump in advance of the charged conspiracies. So stuff that he said before January 6th, saying that there would be fraud in the 2020 presidential election. So not after the election, there was fraud, but before the election, there was going to be fraud. Now, these statements sowed mistrust in the results. So Trump saying that there's going to be fraud coming up in the election is going to harm the results of the next one. And they're going to incriminate him for that. The results of the presidential election, and in fact, those statements laid the foundation for Trump's criminal efforts. So he was plotting this whole thing since before the election even started. In addition to this intrinsic evidence of false statements about the election, the government will also offer evidence reflecting Trump's historical record of making such claims. He's been saying this stuff for years. Now, for example, as early as November 2012, you see how far back they're going? Didn't even have the sparkle of presidency in his eye. November 2012, Trump issued a public tweet making baseless claims that the voting machines had switched votes for Romney to Obama. Okay, so Trump's opinion about 2012 is also used as criminal evidence against him. America. Now, during the 2016 presidential election, Trump claimed repeatedly, 2016, with no basis, according to Molly, that there was widespread voter fraud, including through public statements and tweets. She said that he posted this in October 2016. Tweeting, Trump said, of course, there is large-scale fraud happening on and before Election Day. Why do Republican leaders deny what's going on? So naive. Now, they say that Trump's false claims about 2012 and 2016 are admissible, even though it's not related to the 2020 case, because they demonstrate that Trump had a common plan of falsely blaming fraud for election results that he does not like, as well as his motive, his intent, and his plan to obstruct the certification of the 2020 results and illegitimately retain power. So they're going to, comb through everything, right? Get every statement that they can possibly get and use it against him. And they're going to play this in front of the jury. See this, ladies and gentlemen of Washington, D.C., like 90% plus Democrat left? They're all going to be saying, yeah, he tried to insurrect us multiple times. He did insurrect us in 2016, right? What they think, literally. I mean, Hillary, I think, is still saying that election was rigged against her, caused by the Russians. She's not indicted and under scrutiny from the DOJ. Wonder why that is. Oh, because she's on their team. So here, Molly continues. She says, there's also historical evidence of Trump's common plan to refuse to commit to a peaceful transition of power, right? So he doesn't go along with the people who steal things. And for that, he's now going to be penalized. So to ensure the destabilizing impact of his widespread election fraud claims, so he's like trying to really cause harm to America, in the run-up to 2020, Trump repeatedly refused to commit to a peaceful transition of power if he lost the election. It's like they want to box you in. Hey, if we steal this from you, you're going to be okay with it, right? Well, no. I mean, if you're going to steal it from me, then no, I'm not going to be happy with that outcome. Oh, well, why are you refusing to comply with the outcome of the election? You trying to destabilize America? No, I want to make sure that this is not rigged and fraudulent and fake. Well, sounds like you're undermining American democracy. So we're going to indict you for that. The government, they say, will offer proof of this refusal, that he says, I'm not going to play ball with you cheating, lying people, which we covered here at length, by the way. We've covered all of the lawsuits that were being filed on the back of COVID to manipulate the election deadlines, to seize power, in my opinion, unconstitutionally, away from state legislatures, to have different secretaries of state and different unelected judges just saying, well, COVID's dangerous, so we're going to modify everything. That is fraudulent, in my opinion, because it was not not authorized by the state legislatures. The authorization, the conduct of the election was problematic. So here they say that they're going to say Trump refusing to comply with us, which is like, reminds me of one of those movies, like, you know, The Three Musketeers or something, you know, something in that vein where they're like, renounce your conspiracy or death. You're like, what? And they have to say, no, the king is honorable and truthful. And they're like, good, thank you. Finally, justice. You go, what? This is weird. But that's happening in American courts now in Washington, D.C., not, you know, in the Middle Ages. So here, the government is going to offer proof of this refusal as evidence of Trump's criminal conspiracies because it shows his plan to remain in power at any cost, even in the face of potential violence. For instance, at September 23, 2020, before the election took place, Trump went on a news conference and he was asked, "Sir, win, lose, or draw in this election, in light of many rioting in cities across this country, red and your so-called red and blue states, Mr. President, would you commit to making sure there is a peaceful transfer of power after the election?" Donald Trump said this. Molly, who's combing through his YouTubes, says, "Well, we're going to have to see what happens. You know that. I've been complaining very strongly about the ballots, and the ballots are a disaster." And a reporter interrupted him and said, "But sir, peaceful." And Trump said, "I understand that." Yeah, he said, "I understand that, but people are rioting. Do you commit to making sure that there is a peaceful transfer of power, Mr. President?" Trump responded, I know. We want to have, look, get rid of the ballots and you'll have we'll have a very peaceful, there won't be a transfer, frankly. There'll be a continuation. The ballots are out of control. You know it. And there'll be a continuation is an interesting phrase there, isn't it? We want to get rid of the ballots and you'll have we'll have a very peaceful, there won't be a transfer, frankly. There'll be a continuation. The ballots are out of control and you know it, right? And so this statement must have come, it says September, okay, before the election took place. So he's saying, we're not going to lose, actually, right? There would be a very easy, Trump speaks in words because words are very powerful. Words, I think, etch themselves into the fabric of the universe and they're very powerful. So we use them with care. But he does not, he believes in this. I think if he says something, like if he says it, he thinks it's going to come into fruition, okay? It's a concept of Napoleon Hill. Think and grow rich. You literally will manifest the outcome. So Trump doesn't speak like he's going to lose. There's not going to be a transfer, all right? There'll be a continuation because we're going to win. The ballots are out of control and you know it. And so they're going to say that this is Trump saying, no, you know, I'm going to seize power. But that's not what he's talking about. He's saying that there's not even going to be a transfer. Frankly, there's going to be a continuation. I'm going to remain president anyways, but the ballots are out of control and you know it. And they were out of control. We did know it. This is Molly about Trump. The government will offer evidence that Trump pursued the same strategy 4 years earlier in 2016. He's already done this. Now, in the presidential debate on October 19, 2016, Trump was running, says the defendant was asked whether he would accept the results of that election in 2016, to which he responded that he would look at it at the time, right? Again, if they're going to steal something from you, you want to make sure it's fair before you agree to the outcome. It's like, are you going to sign this contract? Well, I'd like to read it first. No, you got to sign it first. Well, I'd like to see how it was executed. The debate moderator followed up, says, Trump, there's a tradition in this country. In fact, one of the prides of this country is the peaceful transition of power, and that no matter how hard fought a campaign is, at the end of the campaign, that the loser concedes to the winner, and that the country comes together in part for the good of the country. Really? Who did that? Did Hillary do that? She's still complaining about it. Really? Says, are you saying you're now not prepared to commit to that principle? Trump responded, what I'm saying is that I'll tell you at the time. I'll keep you in suspense, okay? That's how it works. So they say Trump and his consistent refusal. So again, right, 2012, 2016, his refusal to commit to a peaceful transition of power, even when he won, which shocked them, dating back to 2016, is admissible evidence. We're going to use that against him as well. And it's part of his plan to undermine the integrity of the presidential transition process by calling out rigged elections. So when faced with the possibility of an election result that he would not like, as well as his motive, intent, and plan, that's the 404B language to get this in. So Molly continues, she says, there's also evidence that Trump and his co-conspirators knew and they had knowledge of unfavorable election results, and they had motive and intent to subvert them. So they knew that this was legitimate and they tried to undermine it anyways. They say here, Molly says, the indictment lists multiple examples of Trump's efforts during the charged conspiracies to pressure state officials to change election results or to appoint invalid electors in spite of the election results, also known as the alternative electors, which have been used in many other elections. No one else has been indicted. The government also plans to introduce evidence of an effort undertaken by an agent and someone else who's unindicted, which I'm still wondering who these people are. Who are these unindicted co-conspirators that are running around? Are they going to charge them? When is that going to drop? I don't think so, because if they charge them, it's going to reset the clock. So these unindicted co-conspirators, I think, are going to remain unindicted. They don't care about them. they'd rather just get Trump on the hook in March. Otherwise, if they bring that with a superseding indictment, and I think this case would reset itself. So anyway, they continue. Undertaken by an agent of the defendant of Trump who worked for the campaign. So some campaign employee who they're not going to charge because it's just a small fish, says immediately following the election, that person was orchestrated to obstruct the vote count. Here's what they say happened. On November 4th, writes Molly, the campaign employee, the unindicted co-conspirator, exchanged a series of text messages with a lawyer supporting the campaign election day operations at the TCF Center in Detroit, where votes were being counted. Now, I don't know what happened in Detroit. We know that there were, water main breaks in other places like Fulton County and elsewhere, saying in the messages, the campaign employee encouraged rioting and other methods of obstruction when he learned that the vote count was trending in favor of the defendant's opponent. And I'd love to see what they redacted out here for us so that we could read it. But of course, these little, prosecutors love to do this stuff in undercover, and we can't see what is actually the evidence. Otherwise, we might be able to refute it, but they blake that out for us, obviously. So the government will also show that around the time of these messages, an election official at the tabulator center observed that as Biden began to take the lead, a large number of untrained individuals flooded the vote center and began making illegitimate and aggressive challenges to the vote count. Was this where they were putting up the barricades for the observers? Was this where they were boarding the windows so nobody could see? Is this where Trump counters were being thrown out of the rooms? Because we saw all of that. Thereafter, Trump made repeated false claims about the election activities at the TCF Center, when in truth, his agent was seeking to cause a riot to disrupt the count. In Detroit, so this evidence is admissible to demonstrate that Trump, apparently, I'm still waiting for them to say, maybe something Trump did is in here. So did Trump, right, we got to follow the bouncing ball. So did Trump talk to the lawyer who talked to the employee who said go riot? Or how did it go? We're still missing that. But they say here, the evidence is admissible to demonstrate that Trump, again, he's still missing from the equation unless he's in that redacted paragraph, the bouncing ball from Trump to the co-conspirators and the lawyers, that they had knowledge that he had lost the election. They had intent and motive to overturn the legitimate results. And that's just one tabulation center in Detroit, which I don't think is generally a district that's going favorable for Trump anyways. It's not a close district or something like that. Like we're going to come out, Chicago's going to turn red, and I doubt it. So here Molly continues. She says, there's also pre and post conspiracy evidence that Trump and the co-conspirators suppressed proof of their fraud claims, that their claims were false, and that they retaliated against officials who undermined their criminal plans, which is just to make sure that an election is not rigged. So here Molly continues, says the indictment provides evidence that Trump repeatedly sidelined advisors and officials who told him or the public truth about the election results and who pushed back on his false claims. He's allowed to do that. He's the president, right? They serve at the pleasure of the president. That's the point. So if two advisors come to him and say, Trump, I think we should bomb this country in the Middle East. Okay, that's an interesting take. What's your opinion? I think we should not. Trump can say, okay, well, here's my take on it. I think you're an idiot. You're gone. And I like your opinion. Thank you. Which is exactly what he can do in the aftermath of an election. Because as the chief executive of the executive branch, that's his job, to go ensure that an election is comported appropriately. Now, Joe Biden is going to do this. Okay, Karine Jean-Pierre is already saying that they're going to deploy people in swing states to help fortify the election. We've already heard that. So it's going to happen both directions, right? And they're going to say that Joe needs to fortify it against Russia and against Trump and his, collusions with Pootie Poo and so on. So the government is now going to introduce additional evidence that this was the plan, which was to sideline these co-conspirators, and that even after the charged conspiracies, Trump and his people continued their efforts to stifle any dissent to their false claims of election fraud, which were still being debated, right? We were still questioning what was happening. There were still cases pending. One such example, says Molly, is the effort by Trump and co-conspirator number one, again, not indicted, beginning during the charged conspiracies and stretching into the summer of 2021 to retaliate against the former chief counsel to the RNC. Chief counsel from RNC, don't know who that is, came out and refuted the defendant, Trump, and co-conspirator one lies. So we have a difference of opinion here. The Republican establishment went anti-Trump because that's what they are. Okay, in my opinion, I think that McConnell, when he goes into the ballot box, if it's Trump versus Biden, where's he going? Okay, it's going Biden, let's be clear. Where's Mitt Romney going? All right, it's going for Biden. Liz Cheney, so-called Republican, who got thrown out on her butt, one of the most embarrassing losses in American history there in Wyoming. Who's she voting for? Joe Biden. Right? Huge numbers of the so-called Republican Party, including people at the RNC, are going to vote against Trump because they would rather see their side lose than Trump win, because that's what they do now. So here, the question is this criminal? Right? Can Trump have a disagreement as the president about the outcome? Of course he can. But they're going to redact this whole paragraph as well because they don't want us to read it. So Molly continues, says the government will also introduce post-conspiracy evidence after the charged offenses is over of continued retaliation against the chief counsel for publicly speaking the truth about the falsity of Trump's claims, including Trump did something. Redacted, 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 redacted. Now, finally, says Molly, in the summer of 2021, co-conspirator 1 took to Twitter to publicly attack the chief counsel over the same issue. Now, Trump and his co-conspirators and his agents and their aggression in stifling dissent against election fraud claims before, during, and after the charged conspiracies is admissible. So not only is the January 6 evidence admissible, but everything before it and everything after. It's there to demonstrate that Trump and his co-conspirators had knowledge that these claims of fraud were false and that they had a plan depicting their election lies as true. And they wanted to show their intent to silence anyone who refuted their false claims. It's starting to sound like a massive conspiracy now. Molly says in paragraph E, we also want to introduce pre- and post-conspiracy evidence of Trump's public attacks on individuals, his encouragement of violence, and the knowledge of the foreseeable consequences. So everything he's ever done, they want to go get. Now, as the government has set forth in length at briefings related to the court's prior order, they say Trump has established a pattern of using public statements and social media to subject his perceived adversaries to threats and harassment. I mean, we're getting into this, it's starting to sound like a little bit like Judge Engeron over here, right? That he has to be silenced, he has to be gagged because he's using stochastic mechanisms to go after his opponents. And that all of this evidence, it's character evidence, right? It's old evidence, it's not even related to the case, but it needs to come in. It needs to be used against him. Molly says, this indictment includes examples of Trump targeting people, including his vice president. Now, at trial, the government will introduce evidence of this conduct, including Trump's public endorsement and the encouragement of violence, and will further elicit testimony from witnesses about the threats and harassment that they received as Trump targeted them in relation to 2020. So we're going to have like a bunch, it's going to be like the January 6th committee hearing again. They're going to bring in probably Clavicle Girl. We're going to hear from her. Cassidy Hutchinson, who's changed her stories how many times? So she's going to come in probably and say, I'm under attack. Maybe they'll bring in the judge's GF, Allison Greenfield, I don't know, to come in and talk about all this stuff. We're under attack. And Trump needs to be gagged, right? And this is all going to go in front of the jury. Okay, this is the point. It's death by 1,000 cuts. Trump is an insurrectionist, has been a menace for decades, and there are real consequences to this, and they're just going to try to make it hurt. So they say the government also plans to introduce evidence from the period in advance of the charged conspiracy. So a bunch of stuff that came first that demonstrates that Trump even encourages violence. For instance, in response, and we knew this comment was coming. We were waiting for this one. For instance, says Molly, in response to a question during the September 29th, 2020 presidential debate asking him to denounce the extremist group called the Proud Boys, Trump instead spoke publicly to them. Remember when they said, Trump, will you denounce the Proud Boys? Denounce the Proud Boys. Trump told them, quote, stand back and stand by. And that is how they're going to connect the dots there. Now, members of the group embraced Trump's words, and those people got convicted of seditious conspiracy, and they're going to prison for decades as an endorsement and printed merchandise with them as a rallying cry. They made t-shirts about it. 20 years in prison. Now, as discussed below, after the Proud Boys and other extremist groups participated in obstructing the congressional certification, Trump made very clear that they were acting consistent with his intent and direction in doing so. He gave them an endorsement after the fact? Let's see. He says, long after the charged conduct, Trump continued to falsely attack 2 Georgia election workers despite being on notice that his claims were false and had subjected them to vile, racist, and violent threats and harassment. So they said, hey, Trump, some people are angry that some other people may have been involved in rigging the election, and they're mad at them, so you can't talk about them, and you just have to agree with us, otherwise you're a racist. You see how that goes. Now, as set forth in the indictment, during the charged conspiracy, Trump and his co-conspirators spread knowing lies about election workers, and they inspired threats against them. In late December 2022, the House Select Committee, which was illegally constituted under H.R. 503, published transcripts of its interviews with election workers, now, which were some of the worst transcripts I've ever seen, in which the woman provided graphic testimony about the threats and harassments they endured after Trump and his agents falsely accused them, which are all illegal, by the way, okay? So it's illegal to threaten and harass people already. They can charge all of those people with crimes. In apparent response, Trump then doubled down and recommenced his attacks on the election workers. He even zeroed in on one of them, falsely writing that she was a liar who stole the country and that she would be in legal trouble. And so the government now wants to introduce evidence of this, saying that Trump and his co-conspirators have a plan to silence those who spoke out against the false election fraud claims, saying he even got after his vice president and that Trump couldn't foreseeably know that this would lead to threats, harassment, and violence, but he continued to attack them nonetheless, saying, Judge Chutkan, it also constitutes after the fact corroboration that Trump had the intent. He knew, because even after it was incontrovertibly clear that his public false claims targeting individuals caused them harassment and threats, he persisted, meaning that the jury may properly infer that he intended the result. So, which is just a wild thing to say. So if you say something that you think is true about somebody and something bad happens to that person, and you say, I'm sorry that something bad happened to that person, but it is true, then they can now automatically transmogrify that into you wanting that bad thing to happen. Pretty incredible. These are government prosecutors, by the way. Like, they would do this to anybody, but they're really excited about doing this to Trump. So finally, evidence of Trump's encouragement of violence and the consequences of his public attacks must be admissible so the jury can hear all of it. And Molly continues, wrapping up, says, post-conspiracy evidence of Trump's steadfast support and the endorsement of the rioters should also be used against him, saying, as described in the government's opposition to the motion to strike some of the bad language from the indictment, the government, says Molly, plans to introduce evidence at trial showing that in the years after January 6, Trump has openly and proudly supported the individuals who she says criminally participated in the obstruction on that day. He says that he's going to even pardon them, right? So Trump promising to pardon them, which is a political policy position, will now be used as evidence that he is an insurrectionist, essentially, even though that has not been charged in this case. So Trump pardoning them, even as he conceded he had the ability to influence their actions during the attack. Now, of particular note, she says, are specific J6 offenders who he has supported, individuals convicted of some of the most serious crimes in relation to January 6. Yeah, the Proud Boys and the Oath Keepers, seditious conspiracy, violent assault on police. During a September 17, 2023 appearance on Meet the Press, Trump said, when asked about the Proud Boys leader Enrique Tarrio, who wasn't even there on January 6, but was actually picked up from jail by Kenny Lazario, if you remember that, when we covered that one, who was an FBI informant, picked up Enrique Tarrio, brought him back into DC. Enrique was not there on the 6th, but then got charged. Trump said, I want to tell you, he and other people have been treated horribly. True. Trump then criticized the kinds of lengthy sentences received only by defendants who, like Tarrio, committed the most serious crimes on J6, which was like nothing. He wasn't even there. And some of the other guys caused some window damage. Great. So similarly, the defendant has chosen to publicly and vocally support the January 6 Choir Group, which is a great organization, by the way. And there's a great YouTube channel called Freedom Express Media that is often out there recording a lot of this, so you should check them out. It says a group of defendants held at the DC jail, many of whose criminal history and or crimes were so violent that their pretrial release would pose a danger to the public in Washington, DC, right? Try doing bond hearings, release condition proceedings in other jurisdictions and see what happens, okay? If these people were rioting during the Summer of Love in Minneapolis, they'd all get thank you notes from the Kamala Harris, all right? Danger to the public. What happened to the Summer of Love and all those people that Kamala was tweeting about, needed to raise money to get them out of custody? They all were. If these people were dumping on the street in San Francisco, right, they'd have a much different opinion on that. The defendant, nonetheless, has financially supported and celebrated these offenders, as he should, many of whom assaulted law enforcement on January 6. And again, I don't condone or support any violence at all. Never have. But what they say a lot of these was like, bumps and bruises, much of it orchestrated by the cops, by the way. We listened to Proud Boys trial testimony of cops. We've seen this corroborated by video evidence of them up on this balcony shooting into people's faces before anything ever happened, right? Lobbing off, instigating the crowd, lobbing off tear gas and other projectiles, popping people's faces wide open, bleeding guts all over the place. And then they said, I wonder why the crowd got agitated as we're being assaulted by officers, right? And then what happens in the aftermath? Again, I don't condone it, but it is a riot, and Trump is not responsible for all of these, consequences. So here, evidence of Trump's post-conspiracy embrace, which is just taking the opposite side of the issue, which apparently is no longer allowed. Can you not even defend the defense here? Can nobody stand up for the J6ers at all, lest you be a part of a criminal conspiracy? It's wild. Evidence of post-conspiracy embrace of particularly violent and notorious rioters is admissible to say that Trump had a motive and intent back on January 6th, that he sent supporters, he sent the Proud Boys, who he knew were angry and whom he now calls patriots, who we've called him that too. Now, to the Capitol to achieve the criminal objective of obstructing the congressional certification, which is just wild. Now, I noticed that they're not using the Oath Keepers as the example here. Molly's not using the Oath Keepers. Okay, Molly's wrapping that up because there's Oath Keepers statements that said they would have gone in regardless of Trump, which is wild, right? So she picks and chooses. Now, in addition, his statements in this time period agreeing that he still holds enormous influence over his supporters' actions is evidence of his knowledge and that Trump had intent to obstruct the certification. Molly says, perhaps most importantly, Trump's embrace of the rioters is evidence of his intent during the charged conspiracies. So he's picking them up after the fact, which is why they can say he intended it to happen. That's his knowing, right? How do we get into his mind to say he knowingly wanted this to happen? It shows that these individuals acted as he directed them to act. And this evidence shows that the rioters' disruption of the certification is exactly what the defendant intended on January 6th. Now, finally, as evidence of his statements about possible pardons for J6, all of that is admissible to help the jury assess the credibility and the motives of the trial witnesses, right? Maybe if these people come in and testify nicely, Trump will pardon them if he wins, right? So all of the witnesses are now going to be subject to credibility concerns because Trump's just bringing you in here to, tell a story. Because through such comments, the defendant is publicly signaling the law does not apply to those who act at his urging, regardless of the legality of his actions. And so this is a serious motion, right? This is a serious opening. And Judge Chutkan is going to grant this. I'm pretty sure most of this is going to be granted because it's Judge Chutkan. There's really no rhyme or reason to this case. She twists herself into pretzels, redefining nevertheless and saying it doesn't apply. And when the logic applies, saying that Alexander Hamilton, even though he wrote about it, there's no evidence about how the insurrection clause or the impeachment clause works. So it's all just kind of madness in this courtroom. And Molly, a government prosecutor who's supposed to be doing justice, but we know who's got a political axe to grind against Trump from her statements even before January 6th occurred, she was already writing against Trump, screaming at him and Bill Barr. So we know what they're up to. They have a vendetta against him. It's a political prosecution. And now they're going to try to go and get everything that he said before January 6th, everything he said after January 6th against him, because that's what our government does. Now, the case is moving forward. So as we predict, right, Judge Chutkan is going to do everything she can to keep this trial scheduled for March because Super Tuesday is right around the corner. It says this pre-screening form, you see here, this is a letter that is from the United States District Court for the District of Columbia. Judge Chutkan, pre-screening form, sent this one out. Dear prospective Group B juror, this pre-screening form is being sent to you to determine your availability to serve as a juror for trial as part of service for this trial. Says here, the juror questionnaire will be used by the parties. When completing this, please indicate general remarks. Please read the summons in its entirety. And please note that a juror questionnaire will automatically be generated. Don't call to request one. The trial for which you will be completing this questionnaire begins Friday, March 4th, 2024, and it's going to last approximately 3 months until after jury selection is completed. And that is a long time. And so let's check our calendar and just confirm we have the Iowa primaries in January. Super Tuesday is March 5th, is the date that I had. Okay, so all right, I think that's a typo for whatever reason that's there. So all right, so it looks like Monday, March 4th, which would mean Super Tuesday is the 5th, right? So that's off. Now, please answer this question about the availability to serve as a juror for this trial. We understand that 3 months is a long time. We're grateful for your service. If you have a legitimate reason that would prevent you from serving during that time, you may be excused from your reporting on February 9th. We do not accept excuses over the phone, so come on here. Now, ordinary work obligations are not going to excuse you from jury service for this trial. Please provide a detailed explanation in the space below as to why you cannot serve. If you've got a medical condition, let us know. Any pre-existing paid-for travel plans, let us know. Please complete this pre-screening form within 5 days of receipt. You have multiple options for submitting your response. Mail it, hand deliver it, or fax the form. Oh gosh, these courts, man. Fax it to us at this number. If you fax the form, please write it in ink, okay? Don't use a pencil, because our courts are literally have fax machines. It's gonna fax it over. Just, no, I request to be excused from serving on this trial. All you need to do, I'm not encouraging you to do this, I'm just saying in a hypothetical situation, if you just did something like this, if you just wrote here like that, I bet that, oh, you're gone. Absolutely, right? That's 100% gone. Don't even have a question for it, because they don't want somebody who would write something like that on the jury, no doubt. So if you wanted to be there, you'd say, yes, I'll be there because I hate Trump. I love DC. I love the government. I love bureaucrats. I hate insurrection. And so I hate MAGA. So we'll just go and I'll be there. So that's what it looks like. And of course, course, Super Tuesday is coming up, and they have that whole thing orchestrated perfectly. We see that Christie has predictions, says that Trump is probably going to be convicted before the election. I actually agree with him on this. I think that they're going to go hard to get it done. Now, I'm not saying that the convictions are going to stick. Okay, I think that there are major constitutional problems in this case, and I think SCOTUS might get involved at some point to deal with it. But is that going to happen before the trial is over or before the trial even starts? Not real sure. Here is what Christie is saying, and this came over from the Post Millennial.
But the Constitution says nothing about a convicted felon if it comes to that, because he's got 97 some odd chances to dodge that, but one of them might stick. Then what? What if the constitutionalist and you say it doesn't say anything about someone?
You know, Adams and Jefferson were relying upon the smartness of the American people, not to elect
them when they were there.
I remember your coverage was really, really good.
Thank you very much.
Especially that 1800 race.
And the powdered wig.
You called it, Neil.
But what do you make of that? That's a possibility.
How about this? He's going to go on trial the day before Super Tuesday. I believe he's going to be convicted in that January 6th trial in Washington, D.C., predominantly because Mark Meadows, as you know, has signed an agreement.
Former chief of staff.
His former chief of staff, one of the founders of the Freedom Caucus, is going to testify against him. He's going to be convicted. Imagine this. If he's our nominee, he won't be able to vote for himself.
But he can be president.
Yes. Look.
And this is when I talk to other politicos that they're not steeped in the battle like you are, but they say, look, if he hasn't been dinged by all of these, indictments, conviction isn't going to make a difference. I think it might.
I think conviction is different for two reasons. One, because it won't be a liberal prosecutor talking about him anymore. It'll be his former chief of staff saying Mark Meadows, committed crimes, because you wouldn't need immunity if you hadn't committed crimes, and that Donald Trump committed crimes on his watch. That's very different for conservative voters to hear that from Mark Meadows than to hear it from Jack Smith. Secondly, this is a jury of your peers convicting you, not, again, the two-tiered system of justice that a lot of people are concerned about. I think it will be very different. The question's going to be, is there going to be somebody who's willing to stand up to him until that moment so that it's not decided? And that's why I said recently, I'm in this through the convention, and I'm in it through the convention.
His supporters.
All right, so that's Christie, and he is having a bit of a difficult, I think, time coming to the understanding that Trump is doing well, and he's really hoping that a conviction is going to change this. I'm not so sure. I think that a conviction might galvanize people into actually supporting Trump even more. I mean, I think they keep trying to indict him, thinking that's going to go somewhere, and I'm not sure that it is. So we also have Representative Luna, who is sending a letter over to the special counsel's office. You can see this is what it looks like here. Tells us, to Jack Smith, from the Committee on Oversight and Accountability out of Congress. You see Jack Smith is getting this letter, and this letter is coming from Representative Luna, James Comer, and Jim Jordan, all three of them on Congress. And here is what it says to Jack Smith, writing, Dear Mr. Smith, the Committee on Oversight and Accountability is conducting oversight of the DOJ, particularly in light of an increasingly zealous commitment to the expansive prosecution of former President Trump, President Biden's chief political rival. Jack Smith, of course, is involved in this. Now, the committee is concerned that your unprecedented investigation and your fervent prosecution of President Trump is not about any true commitment to equal justice under the law, but an increasingly contrived attempt to use the criminal justice system to defame the former president before the 2024 election. Writing, the committee requests certain information concerning your investigation, saying the Supreme Court has consistently overturned criminal convictions against public officials and private parties based on broad theories of prosecution brought under general criminal statutes. And they're referencing several Supreme Court cases. You see this one, 2010, Skilling versus United States versus McDonald, 2016. We got Kelly versus the states, 2020, and Percoco versus the United States in 2023. So three different examples where they say, yeah, former officials are not charged. Here says you are bringing these now based upon broad theories of prosecution. Writes, but Jack, yet you have used just such a theory in your prosecution of President Trump. Instead, you're relying on general conspiracy statutes to allege a conspiracy to defraud the United States. Writing, SCOTUS has held that past attempts to prosecute under such a theory exceed the reach of the statutes on which they were based, including an overexpansive definition of official acts. Writing, in short, these decisions reflect a concern that overexpansive interpretation of these statutes is inconsistent with fundamental principles that, quote, a penal statute must define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited, and two, in a manner does not encourage arbitrary and discriminatory enforcement. Okay, so a lot of legalese here, but basically she's saying there is no notice. Okay, Trump did not have notice of any of these crimes. He was saying he was challenging an election just like many other people challenged an election. He was saying rigged and fraudulent just like many other Democrats have. He was saying things like fight just like many Democrats have. And none of this was criminal conduct until Trump did it. So Trump doesn't have, there's no due process process, right? He just wakes up and now you can be charged with all of this stuff? Saying here, right, it must define the criminal offense with definiteness. So you have notice so that reasonable, ordinary people can understand what it means. Otherwise, you can have deranged thugs like the people at Jack Smith's office who just make arbitrary and discriminatory enforcement decisions. Luna and Jordan says, along with the Committee on the Judiciary, the Oversight Committee exercises jurisdiction over the DOJ. We're looking into you. The committee is interested to learn whether the department considered the Supreme Court's parameters in weighing whether the prosecution of a former president and any analysis developed in the determination about using this conspiracy statute in the first place. So dovetailing with this inquiry is the fact that you purportedly exercise, Jack, complete independence in your decision to prosecute Trump. This suggests that no oversight was conducted by the department prior to your initiation of prosecuting Trump. Of course, you did so pursuant to your appointment as special counsel by Merrick Garland, but consistent with our concern for the lack of oversight regarding these prosecutions, that appointment is and remains constitutionally dubious. Saying, on the other hand, you had complete independence in your multiple prosecutions of President Trump, such that you qualify as, quote, a principal officer whose appointment must come from the president alone, with the advice and the consent of the Senate. So your appointment is a sham as well. Or in the alternative, apparently the department exercised meaningful oversight of you because you are an inferior officer, so as to ensure that your prosecutorial prerogatives were consistent with the admonishment of the Supreme Court referenced above. Accordingly, the committee seeks to understand your own conception of your authority as special counsel to prosecute these offenses in the indictments against Trump. Now, the committee, they say that the need for this information and our constitutional right to it are amply supported by the court's decisions. A Senate committee was investigating whether enforcement of the department were being properly discharged, and so we're entitled to do this due diligence. So in light of all of this, please let us know about the following information. We want copies. All documents and communications concerning your authority to impanel a grand jury in both D.C. and Florida. We want information about documents about who you offered immunity to, and all documents concerning the DOJ regarding any topics about your decision, and emails from the DOJ and you, Jack, about your decision to return an indictment against Trump. Saying, we respectfully request a response from you on or before December 15th. We're aware of our colleagues' request for similar information. We've already sent a number of these inquiries, June 1st, June 6th, September 7th, and so on. And so obviously Jack Smith is going to continue to take these and just put them right into the shredder. Nice one, Luna. Thanks for that. Because all they got to do is just get into the start of the trial, right? Once the trial starts, that's basically where their line is. And then it's all driving towards a conviction. Then the conviction will come, and then they'll use that to try to get him thrown out of the party, off the ballot, or whatever. So we see here that we've got Clay Higgins, who is another member of Congress, who is also articulating, saying Jack Smith's days are numbered. And of course, we're interpreting that peacefully and patriotically, saying that his investigation will be coming to a close because he's doing such a terrible job. Here is Clay Higgins.
Let me say regarding Jack Smith and his request for another list of American citizens under some alleged legitimate investigative effort, I consider it a badge of honor to be on another one of Jack Smith's list. So I can just say that his days are numbered, and American patriots are not going to stand idly by, good sir, and allow our republic to dissolve. We are prepared to fight legally and peacefully and within the parameters of the Constitution with every ounce of our might and focus. The leftists will not take our country from us. We're standing strong, and I thank you for being a voice of truth and freedom.
That's right. They are not going to take the country. We are going to stand tall and continue our peaceful political fight for America. And so that's Clay Higgins. You can see what the prosecutors are doing in this case. Pretty incredible. Everything that Trump said is now fair game. They say, we're going to go all the way back to 2012. Any Proud Boy statements, anything after the fact, promises to pardon the J6ers, all fair game, because they're going to try to use that comment as evidence in the January 6th trial. Now, we're going to be here covering that trial and all of the rest of the Trump prosecution and lawfare onslaught that's happening across America. Thank you for subscribing, my friends. Thank you for visiting robertgovea.com to sign up for our daily newsletter. You can also access all the PDFs that we just went through. They're on the website. The red lines will be available. So check it out, and we'll look forward to seeing you here on the next one.